Okay, I'm joined this morning by criminal defense attorney and former prosecutor Brian Silber. Brian, good to see you. Thanks for coming on. Clearly, we have a few things to talk about here, don't we? Because the prosecution, they're saying that Murdaugh killed his family to distract, right? Distract away from the financial crimes, draw sympathy from it. And, you know, it seemed like a very far out concept until we heard questioning like that, until we heard also from the CFO who says that the inquiries into Murdaugh stopped right when the killings happened, until we heard what he had to say. And so do you think that the prosecution, since introducing the financial schemes evidence, has done a good job at showing that theory, has shown a good job at showing motive?
Actually, I think the prosecution has made a terrible error with this. You know, in my opinion, look, I disagree with the judge on the ruling that he made. I don't think this is admissible. I understand they want to prove motive, they want to prove malice, but the truth is, I see this as a textbook example of evidence that is more prejudicial than it is probative. In the United States, we do not allow character evidence in a criminal trial. We do not allow evidence of prior bad acts in a criminal trial, with rare exception. Okay. And in this case, I understand why they want it. But the truth is, you know, motive is not something the prosecution needs to prove. And this prosecutor, I can guarantee you, in all the trials he's had in the past, I could probably pull out dozens of them where he very passionately argues to a jury, we do not need to prove motive. Yet here in this case, they're trying to do it. And I think they're endangering their conviction. I think an appellate court is not going to look at this favorably. You know, he needs to be convicted on evidence of murder, not on evidence of financial crimes.
Couple of things to note on that. That is why it seems the judge couched it really on the malice component of the murder case, right? You know, not so much the motive, but the malice component. And look, I will tell you, I was surprised that all of it came in. I thought some of it was going to come in, but to have all of it come in at this point, look, the jury, the other way of looking at it is, I think this is beneficial for the prosecution. The other way of looking at it is, despite the idea of an appeal, this could actually help the defense, because it might confuse the jury. It might distract away from what else is the deficits in the prosecution's case. They might say, you know, look, they're having trouble with forensics. They're having trouble with the guns. They might be having trouble with a timeline. This maybe is maybe the jury would see through it. Maybe not. Maybe so. I'm kind of split in this case. I have no idea which way the jury's going. I will go to this, though. On cross-examination of this witness, defense attorney Jim Griffin really dug right into those details. And let's see how he did, and we'll talk about it on the other side. Brian, what'd you think about that? What'd you think of the point that Griffin was making about, you know, the shell casing? Is it realistic that we could look at that and gauge what kind they were from an outside observation at the crime scene?
You'd really have to know firearms and ammunition really well. But I got to tell you, that's not what stuck out to me in that cross-examination. It was one of the first questions where he said, this guy admitted to you that he knew he would get caught. So when we talk about this motive, it just doesn't sit right with me. You're telling me then, you know, Mr. Prosecutor, this guy knows he's getting prosecuted for major financial crimes. He's going to have law enforcement all over him, okay? And you're telling me his answer to his problems is to murder his son and his wife in such a horrific, violent way.
But it worked. But it worked. If the idea is, think about it like this. So I agree, outlandish theory, right? Then again, it's also outlandish to think that a guy would hire a hitman to kill him so that the insurance proceeds go to his son. But it stopped the inquiries. He did gain sympathy. People are like, wait a second, let's back up. We heard
5 seconds.
We heard from an attorney who spoke during that hearing that was outside the presence of the jury, who said, we were suing Alex Murdaugh, and then we were like, okay, well, if this is a real case of his family being killed, we don't think we're going to win this. We're probably going to have to settle it.
I understand that, but it's a very short-lived distraction, and he would have known that. I mean, fine, yes, in the shock of it, you know, when it breaks the news and he's calling friends and family, oh my God, your kid, your wife, you know, But then literally a few days into it, he becomes the #1 suspect. You know, he had to know that that would have been a major, major risk that makes his problems exponentially worse. I mean, a double homicide is not the solution to a financial problem.
I didn't say it was a good reason. I said it's a reason that at least the jury could understand. But I'm also of the opinion, if you introduce too much of this in, Could it backfire on the prosecution? Could it be a distraction? Is it just too much for the jury to consider? And does it show a little? I'll tell you what, Brian, we do have to hit a break. I want to get more into that with you because I like the back and forth that we're having on this. So let's take a quick break.